I'm asking programs, not court cases.
Yes.
Programs.
Yes, programs. The court cases address programs, programs to give women-owned businesses contracting preferences. Those are the court cases I was relying on. They all deal with the kind of programs we're talking about here.
For each agency, you will require?
Well, for the government, yes. I mean,
I want for you to mention to us, for each agency, a program such as the one that we are discussing today is required for each agency?
Well, if by each agency you mean do courts require the government agency or entity doing the contract program to prove discrimination? Yes, they do. In the proposed rule,
don't you say the federal government, instead of saying each agency has to prove past discrimination?
Well, to be clear, I think what the courts require is that there has to be evidence of discrimination in the particular field where the program operates. So it makes sense to say that the agency who's administering the program, they're the agency in the field where the program operates, has to have the evidence of discrimination. That's what all of the cases hold.
Do you think that what you're stating today is clear in the rule?
I think it's clear in the rule that the agency doing the program has to identify evidence of discrimination in the field where the program's going to operate. I think that is clear, and it's absolutely consistent with the cases.
But let me ask you, the test that you're putting out is not more consistent with strict scrutiny?
No, it is not more consistent. It is the intermediate scrutiny test that the Supreme Court and federal courts all over the country have applied to women-owned business contracting programs. It's not a strict scrutiny test that courts apply to race. The test that I'm talking about and the test that's in the rule is what courts, not the justice, but courts have applied to women-owned business contracting programs across the country.
It seems to us that there is a disagreement regarding the test that you're putting out, and you feel that that corresponds to intermediate scrutiny. You're gonna, and I would like for you to state for the record which member of your staff will remain in this committee hearing so that you get the benefit of the second panel. We're going to have legal experts here which totally disagree with the interpretation that you are stating today. Would you please mention the staff of your, the name of your staff that will remain in the committee hearing?
Yes, of course. I will stay as long as I personally can. I have a staff member, Mr. Phillips, behind me, who will stay in. The Justice Department would be happy to do whatever we can to help resolve this disagreement. We're committed to doing that.
Thank you. Mr. Preston, in the preamble to the proposed regulation, the SBA states that RAND provided 28 different approaches to determining which industries are underrepresented by women. The SBA chose one of the narrowest methods to implement the program, even though the National Academies of Sciences recommended that 2 approaches be used. So I would like to know, why did the SBA ignore the National Academy of Sciences in this instance and just use one method?
I'd be happy to, but before I mention that, I think we need to reconcile some information because my staff advises me that both small businesses and women-owned small businesses have gotten contracts.
I'm sorry, Mr. Preston, I'm not. Okay. Can you?
I just want to state for the record here that we need to reconcile some information because my staff has advised me that small businesses and women-owned small businesses have received contract awards under the category that you mentioned. So I would like to make sure that we offer something for the record subsequently. I think, you know, if you look at the guidance in the National Academy of Science, they recommend considering a broad number of approaches to get a broad understanding of the issue. However, when you look at the detailed guidance that the National Academy of Sciences provides, they very specifically mention that monetary awards are critical to compute, that they're preferable because legislatively mandated goals are based on dollars. Dollar value is critical to business success.
I understand that, Mr. Preston, but I'm asking you that the RAND Corporation, the company that you hired to do a study recommended that out of 28, you could use more than one or multiple factors.
Okay. RAND study provided a multiplicity of methodologies, most of which are not defensible, we believe, in this case. There are two concepts, I think, that are clear to understand. The study looks at dollars of contracts because that is the goal we are trying to achieve. They look at underrepresentation based on dollars. The other piece of information they use is 4-digit industry codes, which are much more detailed, which give us better information on underrepresentation. When you use those two concepts, it winnows it down to two methodologies. And that's you know, I can get into a broader explanation, but it's as simple as that.
Mr. Preston, it doesn't disturb you that by choosing the number of dollars amount in terms of contracts given out will only, if you use that criteria, it will cover only 3% of women that are underrepresented. And if you use another method or a combination of more than one, it will show that women are underrepresented as high as 80% in some cases. So it doesn't disturb you that disparity between 3% and 80%?
Well, I think I can describe for you why that disparity occurs, but what I would tell you is it would be a lot easier for me to stand here and provide you and the rest of the federal agencies with a broad set of set-aside capabilities to meet this goal. But what we did is we determined what we thought was the most accurate depiction of what we needed to do to satisfy the statute, the Constitution, and align with the goals.
Yeah.
I think there's some things, I mean...
Let me ask you, of the 28 methods, do you agree with me that any of those will meet constitutional standards?
I don't believe certain of them would meet constitutional standards, nor do I think
At least maybe 1, 2, 3, 4 out of 28.
Well, ma'am, let me, I mean, if you'd like, I can talk about the number versus dollars issue because you brought it up in your testimony. When you look at numbers of contracts going to businesses, it doesn't look at the dollar value going to them. And let me just draw a comparison. If you have a $5 million business with 5 $1 million contracts from the federal government, so 100% of their business is from the government, and you have GE with 10 $1 million contracts from the federal government, so they have more contracts, but it's an irrelevant percentage of their revenues. That small business would be considered underrepresented, even though all of their revenue is coming from the federal government. Numbers, you have got to adjust for the capacity of the firm and their ability to perform. And numbers puts, you know, sole proprietorships on the same basis as multinationals in terms of the numbers of contracts they're capable of performing. That's why that's not a reasonable comparison.
It just frustrated Mr. Preston, because what I'm asking you is, based on the National Academy of Sciences, which recommended to use more than one method, for you to explain why you choose to only use one, when there is going to produce such a disparity in terms of the 3% that you're going to achieve by using one method, or the 80% in some cases if you have chosen to use a multiple methods.
The NAS said that all or most of the methodology should point to underrepresentation. They also mentioned very specifically that heavier weight should be given $2, and they also specifically said that 2-digit NAIC codes were too broad to be used as the basis of disparity, which is what the preponderance of these methodologies used. They even said it's too broad. Okay. And if you look at a 2-digit, let me just make one more comment. We're looking, if a 2-digit NAICS code is retailers. When you get to the 4-digit, you're looking at automobile dealerships, grocery stores, jewelry dealers, you know, and if you don't look at a more detailed category, you might say there's underrepresentation in jewelry dealers, and that would lead you to give a preference to auto dealerships.
Okay.
You have to
so
look.
the National Academy of Science is wrong. Mr.
We're
Preston,
exactly
I have
to
leave with Mr. Shabbat. We have a bill on the floor.